Uyghur Congress and National Crime Agency and others.
Yes, Mr. Fisher.
May it please my lady, I appear on behalf of the appellants, together with Mr. Forster, King's Counsel, Miss Clifford, and Mr. Hopkins.
Yes.
The respondents are represented by Sir James Eadie, King's Counsel, David Perry, King's Counsel.
Yes.
And Mr. Kennedy Talbot, King's Counsel, is here on behalf of the intervener. He sits immediately behind me.
Briefly in the second row.
Yes. Lady, yes. This is an appeal by way of leave given by Lord Justice Singh on the 5th of May, and that was 2023, on the basis there was a compelling reason for this court to hear the appeal because of the importance of the legal and public issues raised. The appeal is brought by the World Uyghur Congress against the respondent following the decision at first instance and following the respondent's decision not to initiate a money laundering or civil recovery investigation in connection with the importation of cotton garments produced by slave labour in the Xinjiang area of China. The World Uyghur Congress is an organisation that strives to promote democracy, human rights and freedom for the Uyghur people. The appellant is supported by Global Legal Action Network, and the solicitors who support them are Bindmans. The appeal is brought against the National Crime Agency at this stage only, the other parties having fallen away by agreement.
Yes.
The intervener that Mr. Kennedy represents is a Spotlight on Corruption, a non-government organisation which campaigns to improve the UK's legal systems. The issues involve the application of the money laundering offences set out in Part 7 of the Proceeds of Crime Act, where criminal conduct has been instrumental in the production of products at the start of the supply chain.
Yes.
There is also an associated point under Part 5 of that legislation. The criminal conduct in question is the involvement of slave labour in the production of cotton garments by the Uyghur people in the Xinjiang Autonomous Region of the People's Republic of China. And there are three issues ready for this court to determine, as foreshadowed in our skeleton argument. The first is whether, at the time when an investigation authority, in this case the respondent, begins a criminal investigation into alleged money laundering or civil recovery of unlawfully obtained property, it needs to be satisfied that it can prove that a specific product, such as a manufactured cotton garment or monies flowing from the onward sale of the garment, constitute criminal property. The second point that is an issue for the court...
Sorry, it needs to be satisfied. It can be proved, or it is proved. It can be proved, did you say?
Yes.
All right.
Yep. We'll look at the correspondence and exactly what they did determine.
Yes.
But in short, our case is that they made a determination that they couldn't prove it, and therefore they weren't going to initiate an investigation. The second point is whether the existence of criminal property must be proved by evidence which identifies a particular act or acts of illegality, or whether the existence of criminal property can be proved by inference. And that's the second point. And then the third point is where adequate consideration has been given by the purchaser of a product, whether the adequate consideration extinguishes the taint of criminality and operates to cleanse the property as it travels along the supply chain. The first and second issues in our submission involve a careful analysis of the meaning of criminal property and anticipating the court's agreement to this course of action. I've asked Mr. Forster to develop the appellant's submissions in relation to the first and second issues that arise. The third issue involves a consideration of the circumstances in which the exemption for the giving of adequate consideration applies, as set out in section 293C. And the appellant's first submission on this ground is that where adequate consideration has been given by the purchaser of a product, the giving of adequate consideration doesn't extinguish the taint of criminality or operate to cleanse the property by acting as a circuit breaker as it travels along the supply chain. It's no more than a personal exemption we submit from liability for the commission.
Because the judge below accepted the NCA's argument that payment by anybody at any stage would cleanse the property once and for all.
That's exactly the point, my lady. And we say that is simply not right, and we propose to demonstrate to you why it's not right. And the appellant's second submission is the exemption that is contained for adequate consideration in the legislation should be construed narrowly, and on its proper construction, we say it applies only in a situation where a person receives criminal property as adequate consideration for the supply of goods and services. In other words, it wouldn't apply where the adequate consideration is the provision of money to acquire property, such as commercial assets. And that is our third submission. So the first two submissions we've labelled the identifiable property submissions, and the third submission we've labelled the adequate consideration issue.
And Mr. Forster's helpfully going to take us through the first two, and who will be doing the third?
And I was proposing to do that.
Very good, Mr. Fisher, thank you.
Yes, and so the importance of the issues, it's right to say, if I may just say this on behalf, is that it's plainly and obviously a situation where the outcome of the case has great importance for the Uyghur people. The determination of the identifiable property issue is one that will impact in all cases where an investigating authority is considering the commencement of a money laundering investigation. The proper construction of the adequate consideration exemption impacts on the application of the money laundering offences, in particular section 329, not only to goods as they travel along the supply chain, but more broadly to other commercial arrangements. And so, for example, issues would arise where corporate transactions, where the property is criminally tainted. Again, we can explore these issues in argument. But we say that also it follows, in terms of importance of these issues, there is a consequential impact on the number of suspicious activity reports made to the respondent. The narrower the ambit of the application of the legislation, plainly the narrower the number of reports that are going to be filed. And that is an issue that needs to be
an overlap
considered.
with section 330?
Absolutely, and absolutely. And that's a matter that is going to be explored with the court's lead. There is important common ground which the court will find helpful, we perceive, in determining the issues. There is agreement that there is a large, diverse and growing body of evidence, and that language comes from language which you will find in the judgment that was in issues, matters presented to Parliament, a large, diverse and growing body of evidence which suggests that cotton emanating from Xinjiang is in cotton products imported into the UK. There's no dispute about that. And also there is no dispute that modern slavery and crimes against humanity can constitute criminal conduct within the meaning of the Proceeds of Crime Act for money laundering purposes. My lady, to just mention a couple of housekeeping matters and to check that the court is comfortable, there is a core bundle.
Yes.
There's a supplementary bundle.
Yes.
And there is a law authorities bundle.
Yes, and I will be working electronically, as I think my lady is, or perhaps not, but if we could have hybrid references
Yes.
to pages and bundle numbers, thank you.
Yes, thank you, my lady. Yes, I don't know if it would help me simply at this point to identify the key court documents. I was going to go through the key ones in more detail, but in terms of the bundle, have you been able? You've located the claim form.
Yes.
And
Yes.
some of the grounds
And
of
before we
evidence.
go to key documents, just in terms of timing, we know that we're going to have the benefit of Mr. Talbot for, I think, up to 30 minutes, according to, in line with the directions that have already been made. How long do you think your side of the case will take to present?
Well, I think on my behalf, in opening the matter, going through correspondence and the legislation, I could do an hour or something of that sort.
And then Mr. Forster?
And Mr. Forster, I think, well, depending on the court's consideration, but we would have thought somewhere between 3/4 of an hour to an hour.
Oh, right, okay.
That's
And then
all.
back to you,
And then back to me.
and then Mr. Talbot. So your side of the case done well within a day, by the sounds of
And
it.
I certainly need to allow a good hour, if not an hour.
Of course, there's no pressure. I'm simply making the inquiry.
Yes. it's
All right, that's
something
very
of that
helpful. And we'll come to Sir James in a moment to ask him what his present thoughts are in terms of timing for you, Sir James?
My ladies, I'm going to be about 20 minutes to half an hour. Just some introductory remarks, because you'll have seen from the judgment the split below was me doing the Foreign Prisons Act and my learned friend Mr Perry doing
Yes.
all the hard
I'm
work.
not going to ask why you're here then, but...
Well, that's a question that's frequently asked in this court, but I anticipate I'll be no more than half an hour, and he anticipates there'll be not much more.
As I said, there is no pressure to finish today, and in fact, maybe better that we come back tomorrow to finish off, but let's just see how we go. It's helpful
Well, an
for
hour
us
and a
to
half
have
between us
a
is the
broad
kind
outline. That's very helpful. But to repeat, no pressure of time. It's important that we hear these important submissions presented as you would like them to be presented.
Lady, thank you. Would it be helpful then if we go straight into the key correspondence?
Yes.
And look at actually, there are two letters really, the protocol pre-action letter
Yes.
and the NCA's response to that letter.
Yes.
That really will form the heart of the court's consideration.
Yes.
And so we will find them in the supplementary bundle, tab 16, at page 290.
That's the pre-action letter.
Yes, it should be.
Always nice to see that the key documents are in the supplementary bundle.
Right.
My lady, yes.
So it's the 16th of July.
If I can assist at all in helping negotiate the court's way around the bundles, then of course please don't hesitate to allow me the opportunity. This is the Judicial Review Pre-Action Protocol letter. And you will see that there's a very lengthy factual background, which really we don't need to go into because of the common ground between us.
Yes.
If we pick it up at page 306, we can just focus on the fact there that the Proceeds of Crime Act legislation was put in issue. Some of it, of course, relates to the 1897 Act, which we needn't look at. So we can see there coming in, actually it's at 305, I think, no, 306, we find the reference to the legislation. And I just simply pointed out to you that it's there. And then the grounds for seeking an investigation, really we will find at page 315. And here we have at 315 setting out for the first time really in detail of what the appellants are saying and alleging they're the failure to investigate these Proceeds of Crime Act offences and setting out there the history that there are no investigations at play at the time and that in paragraph 49 the appellant's contention that there's been an irrational failure to justify. I should make clear that what we are saying in this case is actually the failure and the decision the NCA made was made on the basis of legal errors, errors of law. And this is not a challenge that's being brought under any other heading. And that was the position in the court below and is the position here. So,
Irrationality challenge, purely legal error.
it's legal. There are two mistakes of law here. One relates to the issue of property, criminal property, that it doesn't, on our case, it does not have to be at a level where it can be proven at the time when you are deciding whether or not to commence an investigation. That, in fact, is to put the cart before the horse, and that's the way we put it.
So there's no dispute about what is needed to secure a conviction
No, there
under
isn't.
Section 329, as I see it.
Yes, you have to prove.
That's straightforward. You don't need to waste time on that.
Yes,
We
absolutely.
understand that specificity is required, etc. There's a dispute about adequate consideration as a matter of law, but let's just concentrate on Section 329.
Yes.
It's all a question, what can be seen as a question of timing.
Yes.
What do you need to, you say the error was to proceed as a matter of law on the basis that in order to commence an investigation, you need to know that you can establish to the necessary
Yes.
standard of proof,
Yes.
the ingredients, the uncontroversial ingredients of Section 329 offence.
Yes,
Is
exactly.
that it?
Exactly, and that's why we say it's cart before the horse, because the whole point of the investigation is to see what it throws up.
Yeah.
So plainly, we would say it's an obvious point.
There'd be nothing to investigate. If you've already got enough information to be able to prosecute, you don't need to carry out an
Precisely.
investigation.
And you can't turn around and say at the outset of making the determination whether to investigate that actually, because you haven't got that evidence, therefore you just decide pretty much in limine, we're not going to go any further.
That's why, and obviously we'll be hearing from Mr. Forster on this, but there's obviously a lot going through our heads because we've read in. But I wonder whether it is as clean as you say, that it's not a rationality challenge, because if you look, for example, at paragraph 2 of the respondent skeleton, and I think paragraph 33 of the letter of the 10th of September we're coming to, it sort of, our view is there's no real prospect of establishing it down the line. And so it's all, it may be not as clean as you suggest, but we'll have to explore that when we get there.
Yes, we can come to that. We've
But
got some
as you say, as a matter of law, it cannot be right that you need to know in order to commence an investigation that you can establish
Exactly.
the necessary ingredients.
Exactly.
Point 1. And that's the first hurdle for you. And the second hurdle is to establish that that is the position that the NCA adopted at the time of making its decision not to commence.
Yes.
Yes, thank you. That's helpful to me. I will now be quiet.
My lady, thank you.
Jonathan,
Yes.
I've just taken 3 minutes. You don't need to trouble with any of them.
Thank you. Yeah, thank you. Mr. Foster's just indicating he can take you through all the relevant points, and I certainly don't need to spend any further time on it because he will seek to do that. So we have here at page 329, where the letter comes to its conclusion, really, almost the written peroration at 329, paragraph 71, what the NCA is asked to do. And obviously it is to investigate the matter. And so that's how the territory was set out before the NCA at this point in time in July of 2021. And so really the key point is to look at the response that the
Well, hang
NCA
on,
delivered.
I hadn't focused on page 328. What we are asking the defendants to do, what's relevant to, so decision 1 isn't relevant
Yes.
for today, nor is decision 2.
Yes.
Is it decision
I was going to say decision 3.
right,
is-
decision 3 and 4, decision
Yes.
3.
Yes.
And what you're asking for is impose a ban or formulate a where's the request to investigate.
Well, or explain how a decision not to do either of the above can be justified given the high risk of contravention. So I think in reality, what the appellants were asking the respondent to do was to really to explore what is going on here.
That may not matter, but I mean, that is stretching what's in the letter.
Yes.
Well, that's, my lady, that's how it was put. I can think.
70B.
Yes. Mr. Foster quite rightly mentions paragraph 70 and subparagraph B, which talks specifically about opening an investigation and actually references the Proceeds of Crime Act offences.
You're quite right. Thank you. It's 2B.
It's actually, I took you to the wrong paragraph. It's
Yeah,
actually
thank you. It's
70B.
2B. In relation to decision, yes, I see. Thank you. It was certainly treated as a request to investigate
Yes.
when you.
Well, that's true, which is in the next tab, at tab 17,
Yes.
at page 332. And we have the beginning of the response, really, at paragraph 8, small 2, capital B, at page 333, where in respect of decision 2, A deals with the Foreign Prisoner Act, and B deals with an investigation premised on potential breaches of the Proceeds of Crime Act, is misconceived in the absence of specifically identified criminal property and criminal conduct. So the Proceeds of Crime Act is of no application. So that's clearly referencing the commencement or otherwise of an investigation, and clearly saying that it's not going to happen because there is no specifically identifiable property on the side.
And just without preempting debate, it doesn't say specifically identifiable.
No.
It says identified.
Yes. And so we can pick it up again at paragraph 31 at page 337. So far as it concerns an alleged failure to investigate possible money laundering under the Proceeds of Crime Act, the letter before claim proceeds on a misapprehension. There is no proper basis for a Proceeds of Crime Act investigation. And then that's spelled out in paragraph 32 over the page, where there's the recognition that modern Slavery Act offences are capable of constituting criminal conduct. But then we get to 1 and 2. It is a requirement of section 340 that any criminal conduct is clearly and specifically identified and that the resultant property is specifically identified. It's insufficient for the purposes of the Proceeds of Crime Act to deal in hypothetical scenarios or presumptions in the absence of identifying a specific consignment of goods that is the product of the relevant criminality.
And none of that is controversial.
No, I was just going to say that.
Number one is all,
Precisely.
as I understand it. Yep.
It's number 2, small 2, isn't it? Once the letter before claim raises both the offences, contrary to 328 and 329 of the Proceeds of Crime Act, it's apparent that in the context of a supply chain, 329 is the apposite offence, and I don't think anybody's arguing with that. However, it is a defence under 329(2)(c) for a person to acquire to have possession of criminal property for adequate consideration. That provision reflects the policy aim of the Proceeds of Crime Act, and it's not the function of the regime to taint the bona fide purchaser for value. Rather, it's to seek the recovery of the proceeds of crime in the hands of a criminal to the extent that it may be possible, which is currently doubted, to identify any specific product as criminal property and any particular person as engaging in criminal conduct.
And I think we can read that, so that's helpful. Thank you.
And so, my lady, I'm proposing, but not at this point, but I'm proposing to come back to this and to explore exactly what is said in 32 small 2, because we say on our case it's palpably wrong and reflects a misunderstanding of the legal position.
But you accept, Mr. Fisher, that the final sentence of 32(1) is correct, at least if "and no POCA offence can arise" means we could not get a conviction.
Yes, that is what it means, that you couldn't get a conviction for sections 327, 328 or 329.
Yes.
It's actually expressed too broadly. It's wrong to say no POCA offence could arise, and because there are other offences. I mean, for example, section 330, failure to report, you don't actually have to prove the money laundering taking place. We can have a look at that if it's helpful to the court. So in fact, even this statement, although we accept it in terms of the principal money laundering offences, sections 327, 328, 329, actually as a statement of law is not true. And so this is really how the issues became a matter of dispute between the parties. It's really at this key point, this juncture, where you will see those errors of law quite clearly displayed. If we look at the earlier correspondence, the truth is we really won't see very much to help the court. The best I can do in terms of the early correspondence is to point to page 260, which is a letter from the Revenue on the 7th of July 2020. It's in tab 9.
Page 260.
It's tab 926. Thank you. And it's a short letter that you'll find at page 261, paragraph 5. We agree with your interpretation in this regard. You also ask about the application of proceeds of crime act in the particular context of this correspondence. You specifically refer to section 340. You again suggest that any consignment containing Xinjiang cotton is likely to contain cotton produced. It would seem to us that the question of whether or not the property is criminal property has to be conclusively determined prior to any consideration being given to the possibility of any action as envisaged by the 2002 Act. We would say no, it doesn't. And so this is the first time that actually you see in the earlier correspondence coming through this idea that we really can't proceed with an investigation because we can't say that there's specific...
Well, this is HMRC.
It is.
Back in July 2020.
Yes.
Not entirely clear to me what is meant by any action as envisaged by the Acts. Does that mean actual prosecution? But anyway, you say this is supports your theory that that was the view they took. They thought you need to have probable establishment.
Yes, I mean, I think the reason that I'm presenting it to you on behalf of the appellant is just to complete the history and to show you really where the issue first seemed to arise.
Yes.
Because we've got a lot of...
Well, I can see why you take us to it.
Yes, thank you. I mean, there is quite a lot of other correspondence in this bundle, but I don't think, unless the court feels otherwise, I really don't think there's anything there that will take us any further. And so that introduces you to the correspondence. Is at the end of the day quite neatly confined. The evidence you have before you is also, I would suggest, uncontroversial, and we really don't need to spend very much time, if any time, on it, unless the court would like me to. You have two witness statements from the appellant side, Ms. Minogue and Ms. Rahmat. Ms. Minogue is the consultant solicitor with Bymans, outlines the available evidence of practices of a range of Chinese textile companies. Again, it's not an area in dispute.
No.
And the other witness is the president of the UK representative, I should say, of the World Uyghur Congress, and again describing conditions of coercion, detention, use of forced labour. Again, nobody's arguing about that. There's evidence from the respondent side, Mr. Hugh, but again, I'd suggest to the court that it really doesn't take it any further. He is employed by Border Force. He explains the processes very generically about how importation at the border issues may be dealt with. But again, there's nothing there to help you in terms of determining the issues that are now in front of this court.
In the judgment, in terms of evidence, there is reference, and it's in paragraph 33 of the response letter of the 10th of September, in a section you didn't actually take us to. There is reference to considerations by the NCA, International Liaison Evidence, in Beijing, the head of the Modern Slavery Tactical Advisors Team, and the Modern Slavery Intelligence Development Team. But those matters are set out in the letter, which is obviously in evidence. Is there any evidence of those matters, of the considerations, of the assessment that was referred to there?
The assessment at paragraph...
So, it's my fault.
No,
If we look at the letter of response,
Yes.
at page 333, and we go to the relevant paragraph, 31. You took us helpfully through 31 and 32.
Yes.
Did you take us through paragraph 33? I don't think you did.
No, I didn't.
Right, well, that's what I'm interested in. It goes back to the overlap point as to quite what the basis of the decision was. here there is reference to specific steps taken by the NCA. Is there any evidence of Roman numeral 1?
No, it was.
The assessment is not in
No,
evidence.
and it was a matter that I was going to make a submission to you on in due
Oh,
course.
there we go. I shall wait.
No, not at all. My lady is right to preempt it. One of our points that we will make is that there is no evidence to support the respondents' contentions in this regard. My lady, before turning...
So is that it in terms of the evidence you want to take?
Yes, it is. There's
I just
nothing more
check.
to
Is there
say.
any other evidence?
There's absolutely...
No, thank you.
There's nothing else to say about it. So I was proposing to take you to the legislation next, and then to say a few words about taking you through the judgment. Are you content for me to do it in that order?
Yes.
Thank you. And so the legislation we have in the authorities bundle at page 682. Just bear with me whilst I obtain that file. And so we have at 682, lady, the preamble to the Proceeds of Crime Act. A short point to make about this is the obvious one, that it makes provision for money laundering and makes provision about investigations relating to benefit from criminal conduct or property, which represents property obtained through unlawful conduct, which is a reference to the Part 5 test, or to money laundering, which is a reference to Part 7.
Yes.
And so the other very short point to make, which I'm sure is not going to be contested, at page 683, is of course the contribution that is required by the authorities to the reduction of crime. A relevant authority, and a relevant authority of course includes the respondent, is obliged to exercise its functions under the Act in a way which it considers best calculated to contribute to the reduction of crime. So plainly, we say that we are falling within that as appellants, because that is exactly what we are asking them to do.
Sorry, which bit of the statute were you referring to there, Mr. Fisher?
I was just looking at section 2A,
Thank you.
2A,
Thank you.
page 683.
Got it. Yes, thank you.
And then I was going to take you straight to the principal money laundering offences at beginning at page 862.
Do we need to look at anything other than section 329 onwards?
Yes, I was going to take you to, if it helps you to appreciate my agenda, I was proposing to take you to 327,
All right.
328,
Okay.
329 and 330. I think we do need to look at them. 327 at 862. So 327 is the first of the what are known as the principal money laundering offences. 3271 deals with the concealing, disguising, converting, transferring or removing of criminal property. It's plainly, I think, on any view, widely configured. And you see the way in which the statute works in terms of its framework, that a person doesn't commit an offence. The first person is taken out of this if he or she makes an authorised disclosure under section 338. The authorised disclosure is a concept that comes into the Act, whereby the authorities, typically in this country generally, it's now the National Crime Agency, can decide whether or not to consent to the act, which is known as the Prohibited Act in 3271, taking place. And so what is being said in this subsection in 3272A is that a person actually will not commit a money laundering offence if they make an authorised disclosure and they get the consent to do the prohibited act. It fits, we say it fits perfectly with what the Act is trying to achieve, which is the ability to clamp down on the handling of criminal property and to discover where there has been wrongdoing so that it can then investigate the matter. The very nature of these type of criminal offences is, of course, that they tend to be concealed, and so by having the authorised disclosure route, the NCA is coming into possession of information it wouldn't otherwise have. And the sort of the quid pro quo, as it were, for the individual or a company in this situation, a legal person or individual, is that they can then proceed with handling what is criminal property in their hands in appropriate circumstances and not be liable for the sentence that would otherwise follow if they were convicted under section 3271. And so in that sense, it's a very significant arrangement. There are some other provisions here. For example, in 3272B and C, there are also provisions which take a person outside of the Act in the sense of saying that they don't commit this criminal offence. If, for example, a person intends to make a disclosure but had reasonable excuse for not doing so, then again, that if that's established and accepted, then that is also something that would take a person outside of the offence. Experience suggests that it's not something that's met often, because in reality, if you intend to make a disclosure, you make it. And so actually satisfying the criteria here, it's not straightforward. 372, subsection 2, subsection C, is also a provision which states that the person doesn't commit an offence if they perform their activity in a particular way. Here, the activity is carrying out a function relating to the enforcement of any provision of the Act or any other enactment relating to criminal conduct or benefit from criminal conduct. At first blush, you may wonder what that's about. And what it's actually about is, for example, the police taking possession of proceeds of, let's say, a bank robbery. And in that situation, there would be a potential liability on the face of the police officer, because the police officer knows or suspects that the property he or she is receiving is in fact proceeds of crime, proceeds of the bank robbery. How does the police officer avoid falling into 3271 and committing a criminal offence in that situation? The answer is the police officer relies on section 3272C, because the police officer is carrying out a function, a law enforcement function, relating to this act, namely obtaining a possession of the proceeds of crime, and that relates to criminal conduct. And so we have, as it were, a carve-out from the commission of the criminal offence. There are other provisions as well which are replicated in the other offences, but it would be helpful if my lady would allow me to just run through them at this stage, because we can take them in 327, but they also apply, as you will see in a minute later on. By amendment, we have inserted into this legislation 3272A, that a person doesn't commit an offence where he knows or believes on reasonable grounds that the relevant criminal conduct occurred in a particular country or territory outside the UK, and the relevant criminal conduct was not, at the time it occurred, unlawful under the criminal law then applying in that country or territory, and is not of a description prescribed by an order made by the Secretary of State. Again, you may think it's gobbledygook. It's actually not to those initiated in the legislation. What this is really about is about the definition of criminal conduct in section 340, subsection 2. And we'll come to look at that in a few moments. But the definition of criminal conduct bites on conduct which takes place abroad, where, in the place where it takes place, it's actually not criminal. But we here would have that conduct criminalised. And so we say that in that situation, under Part 7 of this legislation, even though the conduct, when it was committed abroad, was lawfully committed,
It's a crime here.
it's crime here, absolutely. And so that's what 2A is actually about.
And you're showing us this, what, to show how wide-ranging, how extensive, how far-reaching?
Yes, I am, but I'm also going to building up to showing you something else, which is 2D.
Right.
And I didn't want to just go straight into 2D without giving you the context of what this is about.
2A is not going to be argued in this case, is it?
No, it's not. Well, as far as I know, no. No, and so we have 2B, just referencing, in fact, the relevant criminal conduct. It's for minor offences, really. You're not a description prescribed by an order. What's actually prescribed is that offences punishable by 1 year's imprisonment or more. So it's offences which are not punishable by anything.
Sorry, so 2A, subsection B, subsection 2
Yes.
is minor offences.
So 2B, 2A, 2B. 2B is minor offences. This tells you. So 2AB small 2
Yes.
tells you a description prescribed by an order of the state, Secretary of State, and then in 2A, the relevant criminal conduct is the criminal conduct by reference to which property concerned is criminal property. And then we come to another exemption in 2C at the top of page 863, a deposit-taking body that does an act mentioned in subsection 1, that's 327, does not commit an offence under that subsection if it does the act in operating an account maintained with it and the value of criminal property concerned is less than the threshold amount determined. The threshold amount that's determined for this is £1,000. I'd suggest that what this is here for is to reduce the number of disclosure and consent applications the National Crime Agency is receiving for very small amounts, and to relieve the administrative burden on, for example, a bank, a deposit-taking body, that would otherwise have to report movements of money under this provision under 327. So, for example, every time somebody who was suspected used their cash dispenser and they drew out £100, there would be an issue about whether or not, without this, the deposit taker would have to make a report. Here, this is effectively saying, don't worry about it, you're a deposit-taking institution, you're operating an account for somebody, and it's less than £1,000 that is concerned in the value of the property. So, therefore, an offence is not committed. 2D is something different again. A person who does an act mentioned in paragraph C or D, subsection 1, does not commit an offence under that subsection if carrying out a business in the regulated sector that is not excluded business, P does an act in the course of that business in transferring or handing over to a customer or client money or other property or owing to a customer and for the purposes of the termination of P's business relationship with the customer or client. The total value of the criminal property transferred for these purposes has got to be less than the threshold determined under section 339.
And that's again 1,000.
Yes,
Yep.
and before the act is done, P has complied with the customer due diligence duties. So it's really a situation where the person carrying on a business in the regulated sector is really somebody who is carrying on a business in terms of delivering financial services. Typically it will be banks, of course, but it also is much wider than that. It includes lawyers and accountants, etc. I'm sure the court's familiar with that.
Michael, why does that help us?
What is interesting is that there is an exemption that is here at all, that a person doesn't commit, does an act, does not commit an offence if they hand back to the customer in these situations. So the question is, if for example, P, who's carrying on the business, is providing a service, the adequate consideration defence would presumably apply to their acceptance of the money in the first place. If they are then handing it back to a customer or client money, as is described, if they are then handing it back, they have an exemption. They need this exemption because otherwise they would have to make an authorised disclosure. That's why it's here. And the point is this, if the person who's doing this in the regulated sector has the benefit of the adequate consideration defence when they first took the money in from the client, then in those circumstances it suggests that the property, that the money they're holding, still retains the characteristic of being criminal property. Or to put it another way round, it must mean that the money is not being cleansed by the adequate consideration defence. Because if it had been cleansed, there would be no need for this provision.
So it's an adequate consideration point.
It is an adequate, yes. And then we have a further write-out in 2F. The person who does an act mentioned in paragraph C, D, or E of subsection 1 does not commit an offence under that subsection. If they're carrying on a business in the regulated sector, they do an act in the course of the business. At the time of the act, they know or suspect that part but not all of the funds in the account or accounts are criminal property, and the value of the funds in the account or accounts or the property so held is not as the direct or indirect result less than the value of the relevant criminal property. Again, at first blush, you just might be taking a deep breath, and it's really about what's become known as mixed funds, where, for example, so it's where you've got an account, and let's say you've got £100 in the account, £50 derives from criminal activity, £50 from lawful earnings. So you've got the mixture, and the question is, how do you deal with that? Because under the definition, which we'll come to in 340, the whole of that is designated criminal property. And so what this is saying, well, actually, if you do want to handle the legitimate part of the monies contained in the whole, i.e., you want to deal with £50, then that's fine, provided you just make sure that you confine yourself in dealing with it to the amount that represents legitimate obtained monies and not criminally obtained monies. So it is a little tortuous, but that's what it's there for, to relieve that situation. So it's not an adequate consideration point, it's just simply letting you see the totality of these provisions. And so if we move on to section 328, the arrangements offence at page 865, you have there this offence of committing an offence if you enter or become concerned in an arrangement which he knows or suspects facilitates by whatever means the acquisition, retention, use or control of criminal property by or on behalf of another person. And so this is the offence that takes place, actually, even where you don't have to handle the money itself. If you look at 327, 329, you come into those offences if you're handling money. Actually, 328 is an offence which will bite, where, for example, a professional person becomes involved in an arrangement with their clients, let us say, or some counterparty, to acquire, retain, use or control criminal property. So it's an offence that is in reasonably wide currency, certainly amongst the professional community, we're very aware of it and its terms. One of the ambiguities not before this court today is the meaning of an arrangement.
No.
But
No.
we don't need to go there.
No, we don't.
But I just mention it. And then again, we can do this much more quickly now. We can see subsection 328, same arrangement, authorised disclosure, and also intending to make a disclosure, and also the enactment carrying out a function related
So we
to
can
the-
read 328
So,
for the
exactly.
particular,
and
and then
you-
we get to 329.
Exactly. And so we come to 329 at page 868. And so again, we have a similar structure in the sense that we have the criminal offence. A person commits an offence acquiring, using or possessing criminal property. It is also subject to the authorised disclosure exemption.
Yep.
That person doesn't commit an offence.
Yes.
He intends to commit. And then we have something new in 2C, which of course is what this appeal is about in part, is acquired or used or had possession of the property for adequate consideration. And so that's inserted here in the list of exemptions. And so we have the same insertions at 2A, 2C, 2D, 2F, but we pick up adequate consideration again at section 329(3) on page 870.
Yes.
And this is, of course, for the purposes of this section, we then have three provisions. A person acquires property for inadequate consideration if the value of the consideration is significantly less than the value of the property. A person uses or has possession of property for inadequate consideration if the value of the consideration is significantly less than the value of the use of possession. And the provision C, by a person of goods or services which he knows or suspects may help another to carry out criminal conduct, is not consideration. So here we have the heart of the discussion that we're having about adequate consideration and when it applies. So we would say that subsection 3 is a limiting section. It plainly, in our submission, limits the application of the exemption, because the exemption has been provided for, but then in terms of its application, we've then got some write-outs from that. And so,
Sorry, got some.
Write-outs from that. So it is essentially a limiting subsection. And so the questions for the court: when does it apply? What are its limits? And what does it mean? What does it do? Does it do anything to the nature and the character of the criminal property? And so these are matters that we are going to make submissions to the court about. Section 330, page 871.
Yes.
Yes, this is the failure to report section, which of course moves away from the subjectivity of sections 327, 328 and 329, where you commit that offence where you know or suspect that money laundering has occurred. And that's where, under those offences, you have to prove that the criminal property exists, and you have to prove that it is in existence. Section 330 is different. It's a reporting requirement. You are required to report if you, I'm in subsection 2, you know or suspect or have reasonable grounds for knowing or suspecting. That's why I say this is now the objective criteria that's being applied. The second condition is that the information comes to you in the course of a business or the regulated sector. So the information has to be passed to the individual or company that is acting in the regulated sector. And then we have some further requirements put in by amendment that you are able to identify. So when you're making the report, you need to be able to identify the other person mentioned, i.e. the suspected money launderer, or the whereabouts of any laundered property. So we just say to you, notice the alternative, notice the or, and that you believe, or is reasonable to expect to believe, the information or other matter mentioned in subsection 3 will or may assist in identifying that other person or the whereabouts of any of the laundered money, or property to be accurate. The fourth condition is that you fail to make the disclosure to the nominated officer. We can shortcut that by saying that in effect is the National Crime Agency, the respondent. And then at subsection 5, the required disclosure of the identity of the other person mentioned, if he knows it, the whereabouts of the laundered property so far as he knows it, and the information or other matter. It's a very short point that we would make on this, leave this, which is that it's, in making this submission, there may not necessarily be clarity at this stage over the laundered property, over what it is and what it amounts to. But you are still obliged to make the disclosure, as you can see from section 330, if you are operating within the legal sector, or for example, any other profession within the regulated sector, then...
You have reasonable grounds for knowing or suspecting.
Yes.
That's
Exactly. And that's why the criminal property does not need to be proven in order for the Crown to get a conviction under this offence. So it is different in specie from 327, 328, 329. And so it's also the provision, if I just take you to subsection 6, page of 872 for the sake of completeness, where the exemption is that you don't commit an offence if you have a reasonable excuse. So notice that's not tied anymore to making a disclosure or an intention, or if you're a professional legal advisor. So here we have a provision that safeguards legal privilege. And so that's in here. And then we have a definition of legal privilege, which is not an issue in this case. So I don't need to it in any detail at all, but just to mention to you and help you orientate yourself around the statute, how it works.
Thank you very much.
And so before taking you to section 340, I ought to just mention section 338 at page 910. And the reason that I'm taking you to 338 is to show you what an authorised disclosure actually is within the terms of the legislation. Because you've met it now in 327, 328 and 329 as being a way out of liability where there's an authorised disclosure. And this is what an authorised disclosure is. It's authorised if it's a disclosure to a constable, customs officer, or a nominated officer. As I said, typically that will be to the National Crime Agency as the financial intelligence unit for this country. And then you have to also satisfy first, second, or third condition.
Do we read 338 to ourselves?
Yes, with pleasure.
Yes. Happy? Yeah. Thank you.
Thank you. My lady, you may wish to undertake the same exercise with section 340, which is an important section. It's at page 941. It's important because you have the definition of criminal conduct in 342 and the definition of criminal property in 340 subsection 3. And then, of course, as you read on, you'll see the different manifestations of what property can be.
Give me the page number for 340, please.
It's 941
Thank you.
is 340.
Yep.
Please, my lady, may I say just a few words about section 340, subsection 3?
Yes.
As I anticipate that it's going to be a battleground. Well, I don't know about battleground, but it's certainly going to be the centre of focus as we develop the discussion. It's the definition of criminal property, and what you notice about it is that it has this ability to define criminal property by reference, first of all, to whether or not it does actually physically constitute a person's benefit from criminal conduct, or represents such a benefit in whole or in part, directly or indirectly. So it's a definition that is expansive. It plainly expands, artificially, one might say, the definition of what criminal property is by reference to its in whole or part, and whether directly or indirectly. But it's also a section which makes clear that property does not become criminal property unless not only is it derived from a person's benefit from crime, but actually B, the offender knows or suspects that it is, that he knows or suspects that it constitutes or represents such a benefit. You may see this drafting as a moment of brilliance. You may, on the other hand, see it as a complete disaster. In a negative way. Why do I say that? It's because, in a sense, you can say that it's really difficult to define the nature of something, this physical characteristic of whether something actually amounts to criminal property by reference to what another person thinks about it. So you certainly can have a situation where the same item may be criminal property in the hands of person A, but not in the hands of person B, depending on what, respectively, A and B knew about its origin. Because as far as Mr. A is concerned, if Mr. A knows that that particular property has a criminal origin, has been bought as a result of crime, benefit from drug trafficking, then it's criminal property. But if Mr. B hasn't a clue, the same item of property is not going to be property, criminal property at all, certainly not in his hands. And so in that sense, in one sense, yes, it's really difficult because you might say, well, we don't know whether a particular item of property actually is criminal property or isn't. We've got to find out what somebody else knows or suspects about it. On the other hand, you may say it's a moment of brilliance because what it does do is ensure that not every penny in the pound, as it were, in the United Kingdom becomes criminal property. There's going to be, by definition, a fluidity written into section 340, subsection 3, is a fluidity about the notion of whether something is criminal property or not. Whether or not, and that's going to depend on what their state of mental awareness. So it's a real confusion, in one sense, of the mens rea and the actus reus. But on the other hand, in terms of the Proceeds of Crime Act, one can see what the statutory draftsman was seeking to achieve. And then we have the definitions, further definition of what actually property can be. And we can develop examples where in the commercial context, I mean, that can be buying a share or even an option to purchase a share. Any form of property can be caught by this legislation. And lady, I need to just take you to section 341 very briefly, at page 944.
Well, isn't this important, section 341?
Well, yes, I do need to take you there. It is. For money laundering purposes, I mean, this defines investigation and makes clear what an investigation is. It actually does so in terms of money laundering very shortly. At page 945 in subsection 4, a money laundering investigation is an investigation into whether a person has committed a money laundering offence. So that tells you what the investigation is. And again, just to be clear, I jumped over...
Overlapping into the Part 5 investigation, civil recovery investigation.
Yes, just before we get there, can I just link subsection 4, for the purposes of this part, a money laundering investigation is an investigation into whether a person's committed an offence. You have a definition of what a money laundering offence is in section 340, subsection 11. And so that
That's just section 327, 328, 329.
Well, yes, but it tells you what a money laundering, it tells you what money laundering is.
Yes.
So if you're going to be investigating under part 8 of your powers, which is the part that this act is, that this section is now in, if you are going to be investigating whether you've got a money laundering case, you need to know what money laundering is. And so I'd suggest that the definition in 340 subsection 11 is not confined. I think you would read subsection 4 of section 341 as referencing what a money laundering act is and what you are investigating. And then my lady is right, of course, and has got there before me. Section 341 at page 944, subsection 2, defines what a civil recovery investigation is. So, of course, this is now moving into a different part of the Act, part 5 of the Act, where Parliament has set up a scheme for an enforcement authority to take action, civil action in the High Court against property unlawfully obtained, to take action against that property in rem. And so in order to find out what a civil recovery investigation is, you have to look at 3441 subsection 2. And of course, it is interesting to note its width in terms of the definition of identifying what is going to be recoverable property for the purpose of section, for the purpose of part 5. A civil recovery investigation for the purpose of identifying recoverable property is or has been recoverable property, who holds property, what property a person holds, etc., etc. Plainly, at the time of initiating an investigation, you may not know exactly what the shape of criminal property, of recoverable property is under proceeds of Crime Act Part 5.
Sorry, I've probably missed this, but recoverable property in section 341, subsection 2 is defined where? We're coming on to that.
No, I'm going to take it. Once you gain your step in front of me. Page 691.
Yeah, thank you.
Is section 240.
Section 240, that's right.
Yeah. Right. So, yes. So page 691, general purposes of this part of the Act, section 240, so we're in part 5, we're in civil recovery territory. This part has effect for the purpose of an enforcement authority recovering in civil proceedings before the High Court, or who represents property, which represents property obtained through unlawful conduct, and that's what this is about. Enabling property which is or represents property obtained through unlawful conduct to be forfeited. The powers conferred by this Act are exercisable in relation to any property, whether or not proceedings have been brought for an offence in connection with the property. And so you have a definition of unlawful conduct that would form the basis of an application for civil recovery in page 692 in section 241. And what you'll notice about the definition of unlawful conduct is in its definition in 241 subsection 2, conduct which occurs in a country or territory outside the UK and is unlawful under the criminal law, and if it occurred in a part of the UK would be unlawful, is also unlawful conduct. In other words, there's a double criminal test here, which is different from the money laundering test. I suggest that not very much, if anything, turns on that for the purposes of this appeal. But a lot turns on it in practice. I'm sure you appreciate it. Particularly, for example, in bribery-type cases, where one takes, in a commercial context, the type of conduct that occurs abroad, which it may be lawful, but actually would not be lawful here. And so that's what 241 sets up. And of course, being civil, the court must decide the issue on a balance of probabilities. It's not just unlawful conduct that can ground a recoverable property civil action. Section 241A, gross human rights abuse or violation at page 694. And then I want to... to take you to section 242, property obtained through unlawful conduct, 698, property obtained through unlawful conduct, section 242. And it's interesting that here you have a specific provision which says that in 242 subsection 2b, it's not necessary to show that the conduct was of a particular kind if it's shown that the property was obtained through conduct of one of a number of kinds. And so you have this difference of approach to determining what is recoverable property for civil recovery action. Just bear with me one moment, please. I know Mr. Forster would wish me to take you to a particular section.
I just wonder if it'd be simpler if I illustrated this for you. If you were to go back to the core bundle, you'll see what Parliament intended so far as the government's reading was concerned. This is the human rights provisions in section 241(2)A. And if you could please pick up that bundle at 743, please. So this is our original grounds where we set out the government's impact assessment.
743.
743, my lady, thank you. Because it is a neat example of the use of slave labour, of which this case enjoins, and why we say civil recovery is the apposite issue in this case. And so that the government's impact assessment, which we set out there, it's not digested in the authorities, was the example to illustrate the impact of 241A, where Mr. A was paid a salary by an overseas government to run an internment camp
You want
on
us
that
to read
country.
these three paragraphs?
Yes, please, thank you. That's just to illustrate the issue.
Yes, that's helpful.
You.
Wait a minute. Yep.
Thank you. I'd like to take, if I may please, to section 308 at page 832, which is a provision that provides for an exception in terms of recoverable property. 3081, a person disposes of recoverable
Can
property.
you just pause a minute, please,
Yes.
Mr. Fisher? I've got to go back to the other bundle.
Of course. Tom.
Thank you.
Page 8.
So we're into the authorities page
832.
I'm at 832.
832. Thank you.
827 is the definition of recovery.
Yes, thanks very much.
Thank you. So I was going to take you through section 308, just to make the point that the legislation provides for a situation in Part 5 for where a person obtains a property in good faith for value and without notice. That's 3081, subsection 1. If a person disposes of recoverable property and the person who obtains it on the disposal does so in good faith for value and without notice that it was recoverable, the property may not be followed into that person's hands, and accordingly it ceases to be recoverable.
Sorry, subsection
It's subsection 308, subsection 1.
Yes.
1.
And so if the court wants us to see an example of a legislative provision which makes it clear that the contamination comes to an end on a bona fide purchaser acquiring something, it's here in section 308. And so I should simply answer my lady's question, which I have not answered hitherto, which was, where do I find the definition of recoverable property? And it's in section 304, at page 827. Property obtained through unlawful conduct. And then you remember I showed you the definition of unlawful conduct.
Yes.
My lady, we could spend a lot longer on the Proceeds of Crime Act and its legislative provisions. I wasn't planning on doing so unless there's anything else that I've
No, thank you very much.
would
Very
like to look
helpful.
at. So what I was proposing to do now, reasonably shortly, is to simply identify within the judgment the areas of interest for this court,
Yes.
and then to hand over to Mr. Forster. So the judgment is in the core bundle at tab 16. At page 614. And so you have at page 623 the reference at paragraph 21 to the correspondence, the key correspondence that you've seen already, and that certainly we will come back to in terms of submission. And the whole passage, the critical passage from the NCA's reply to the protocol letter is set out at paragraph 21. So the judge looks at that, and then we can pick up an analysis at pages 629, I think. Yes, of the Proceeds of Crime Act. And these are the provisions you've already looked at, and you can see over the page, it's page 630, the provisions we've just been exploring, running through actually to page 633. We then have areas that are not in dispute, the reference in the cases, paragraph 35, and to Montila, Anwar, GH, paragraph 38 at page 634. So the judge goes through all of that, and then picks up with civil recovery that I've just taken you to, page 635. So he then looks at the civil recovery sections that we've been speaking about. And then we get at page 637 to his discussion, his submissions and conclusions, he calls it. I wasn't proposing to take you through the detail of this because some of it, of course, includes the 1897 Act, which is not a concern for us. We really pick it up at page 642.
Yep, paragraph 67 through.
Yeah, my lady's there.
Yep.
Exactly. As you can see how the judge treats this, he sets out at 69 his understanding of 3292C, He sets out the respective arguments as we go through 70, 71. And I suppose we really come to the real heart of it. Obviously, we've got paragraph 73 at page 644. And in terms of adequate consideration, we pick that up at paragraph 75, page 644. And essentially, without wishing to summarise it unfairly, essentially, the learned judge is taking the respondents' arguments, the NCA's arguments, and he's running with them, he accepts them. And his judgment really doesn't take us any further than the NCA has set out the position before him. And so you then come to his determination, paragraph 80, page 646, where he says he's reflected on legal errors. He deals with the position as he sees it, the bottom of paragraph 80, a few sentences.
Well, that's the key point we're going to be concentrating on is...
It is.
Really, so 80 is all correct on your case. It's the last sentence that's the problem, you say.
Yes.
So you say that, yes, all of that is orthodox and accurate, but what approach justifies the approach they've taken to the material provided?
Exactly.
That's the question.
Exactly. Exactly.
That's the finding. Am I right about that? That's the key
That's what it comes
finding that you seek to
Yes.
challenge.
Yes. And then over the page, he deals at paragraph 85 with the additional complexity, as he refers to it as, or I think the NCA regarded as such, which is adequate consideration. And he deals with that, and he adopts the NCA's line. And we say respectfully he was wrong, and I propose, with the court's leave, in due course, to very shortly invite Mr. Forster to deal first to grounds of appeal as to why we say he's wrong.
Yes, just
And
going
then-
back to
yes.
that last sentence in paragraph 80 for a moment, please. Does he identify does he make a finding as to what approach the NCA took to the material provided?
My understanding and reading of his judgment is that he took the NCA line, which was, as we understand it, looking at the correspondence, that they are not going to initiate an investigation in a situation where they have not got proof of the existence of specific criminal property. And my understanding of reading the judgment in different places, you just read it as totality, is in reality that is what the learned judge was saying. He accepted that.
So when we say justify the approach they've taken to the material provided to them by the claimant, namely that no investigation was warranted
Yes.
without proof of specific criminal property.
Yes, and that's what they're saying.
Yeah.
And we say that's simply wrong.
I agree, but this is the key point for me at the moment anyway, is what is the approach one of the key points is what approach did they take? Because it's not
Yes.
absolutely clear from the 10th of September letter to me at the
No,
moment.
one of our submissions is that they didn't take any approach, that they should
Yeah.
have commenced an investigation and looked around for material to see whether or not this was something that should be pursued.
Well, we know that's your complaint, Mr. Fisher. I think the concern that my lady has, which I share with respect, is what approach they actually took. The one that you're criticising, was it an approach of saying, as you would put it, we'll put the cart before the horse? In other words, we won't investigate until we know what we'll find at the end of the day.
We say that's exactly what they were doing.
Yes.
There was a room with a door, and they
Yes.
refused to go through the door in order to see what was in the room.
Yeah.
And in due course, if it becomes necessary, I was going to spell out in terms of submission what we say they could have done. And we would go further and say they should have done.
Sorry.
Mr. Fisher, could you just give us a preview in a sentence or two as to what you say they should have done?
Well, yes, I can. For example, if you go to the Foreign Affairs Committee report and you go to what the Foreign Secretary said in Parliament, for example, there, I can't remember which one it was, but one of them, I think it's the Foreign Affairs Committee report, contained information about certain companies which had decided not to continue with their relationship with Xinjiang. For example, I definitely remember Next is mentioned as one company that was changing its position. They could and should have taken steps immediately to initiate an investigation and to have discovered what information they were relying upon to find out what was going on. They should and could, it was within their power, to serve production orders. They didn't do that. They could have, they say in one of their letters, well, you know, very difficult to get cooperation from China. They could and should have looked at the position. There has certainly been precedents where legal mutual assistance has been granted by the Chinese authorities. There are various things. So, my Lord, in terms of giving you a preview, that's just a couple of them.
Thank you.
Yes, so this really takes us to the end, I think, of an analysis of the judgment, which we will then come back to. Just before I do hand over to Mr. Forster, and I appreciate my lady's patience in allowing me to do this, if I may just say this, that the issues before this court, we say, involve innovative, interesting, and important matters relating to the application of the UK's anti-money laundering regime. And they are very interesting, I'm sure, to everybody in court who has any interest and little or love of the law. But underlying these issues, we say, and we just mentioned to the court, is a human tragedy concerning the Uyghur people and their subjection to slave labour and other crimes against humanity. And we're sure the court would like to know and acknowledge that present in court and public are representatives of the Uyghur community, and in some cases, as I understand it, who have not seen or heard from their families. We just want them to know that as we argue the points of law, we've not lost sight of their troubles.
Thank you very much indeed.
I pass over to Mr. Forster.
Thank you very much, Mr. Forster.
Lady, I'm going to do three things essentially in developing this principal point about putting the cart before the horse, as we've rather inelegantly put it. Firstly, look at what in my submission is the critical plea about that point that we made in the pleadings. Secondly, what the respondent's response was to it, so that you can see how the issue was joined. And then three, look at the NCA's decision letter to see how that's developed from it, and then look at the judgment and see what the judge did about it, the learned judge. So those are the four things I want to do.
You say you've just helpfully gone through it. I mean, you really focused on the requirements of POCA, Section 329, which are subject to the adequate consideration aspect, aren't necessarily that contentious. But the real question from your point of view is the timing point that we discussed earlier. So what I would really, I know you're going to do this, it's clear from what you've just said, is I just need to have as much clarity as possible, fairly put, on what the basis of the NCA's decision actually was, so far as we can tell from the contemporaneous documentation.
Yes, and I'll hopefully do that. And at the end, can I just come back to a couple of points that I'd like to make, which is slightly not on my territory, if you like. Just firstly, just about family property and how that does work within POCA, because it's an issue that the respondent takes, that POCA doesn't generate a growing family of property, and in my submission it plainly does, and particularly so far as civil recovery is concerned, it plainly does. And I'll just take you very briefly to those sections that do that. And in addition, can I just take you to a point that you just raised with my learned friend Mr. Fisher, my Lord Bean raised, about, well, what do you suggest they should have done? And can I just deal with that right now whilst it's fresh in your minds? Because there is some material in the supplementary bundle, supplementary bundle at page 249, which is one of the letters that Glan wrote to the respondents collectively before the pre-action protocol letter was made or written. And at 249, Glan set out at paragraph 11 some important matters in this regard in a table.
Yes.
They name the importer, and I'm not going to recite their names, but they named the Chinese supplier. And those Chinese suppliers were named throughout this correspondence, and they were called the implicated companies. And there were 4 of them. That's an example of one there. The next one in the next row down is another example, and then the 3rd row another example, and then the 4th row down another example. And they provided in this evidence not just the names of these companies, but where they operated, the sorts of activities that they got up to, and importantly, shipping documents demonstrating imports into the United Kingdom from those implicated companies. And so those who instruct me had provided, we would submit to the respondents at that stage sufficient information, particularly documents to do with shipping of these imports, tainted imports, that was there and ripe for investigation. So it wasn't just simply a complaint about the dreadful state of affairs in Xinjiang. It was providing them with concrete documents that gave them proper leads of inquiry. So can I go back to my issue in this case, which is the timing point. And the first issue I'd like to draw your attention to is how in the core bundle of pleas, at tab 21, in the original statement of facts and grounds by the now appellant, that the critical plea, as I'm going to call it, was put. And if you could please turn up page 707 of that bundle. I scroll through to find it. Forgive me.
No, it's the timing, but before a criminal investigation can even commence. That's what I've highlighted.
Yeah, so
Is
there's
that right? Page 707.
707, and you can also
Subparagraph
see
three,
it at
decision
708.
Yes.
And it's also developed, just for your note, at page 730, at paragraph 63, and 743 at paragraph 118. So the critical plea was all about timing, and the respondent's case in replies at tab 20, and in particular at 672 of this bundle,
Why is the reply in before the statement of facts?
I don't know, it's not very helpful. I think it's in reverse chronological order.
Sorry, can you give us the reference again, please?
Yes, it's page 672, please. And it's Roman numeral 3, right at the top of the page. What they call decision 3 and decision 4, which is essentially the grounds that I'm covering. And they state they collapse into a single point, namely that it's not possible in the present case to identify nor has the claimant in fact identified any criminal property within the meaning of the legislation. And in my submission, therefore, they were putting in issue, therefore, the point that it was for the claimant at that stage to positively identify criminal property before they would...
Well, not necessarily. It says it's on the timing point. I mean, I understand it says nor has the claimant in fact identified, but that could be a little slide dig. But your better point, perhaps, is it says it is not possible. Well, if that's certainly the present tense. But the next section helps you, doesn't it? Because
Yes.
it's all suggesting you need to know all of that now before you go forwards.
Correct. And just for your note, that they repeat this language at page 681, paragraph 22, 684 at paragraph 32. And I invite you to look at those paragraphs to see how, therefore, they put their response to that critical plea.
Or should we just have a quick look at those two
Yes,
paragraphs, please? 22.
So 681. Paragraph 22, they say the claimant's challenge proceeds on a fundamental misconception. For POCA to be of any application to the present issues, it's first necessary to identify criminality or unlawful conduct falling within the scope of the legislation. It has not done so.
That's a slightly different point, isn't it? Criminality or unlawful conduct, not criminal property.
But their point was, unless you can identify any of those things, linking it to property, there simply isn't anything for us to investigate. That's the point they're making there.
Lily, could I invite you to read paragraph 21 just before you get to paragraph 22?
Yes, certainly. I'll take them out of it.
You mean it's under... It's dealing with the first ground, but then it goes... Is that the point?
First ground as to any failure of investigation.
In respect to investigations under CMA. Yep. Gone blank. What is CMA?
It's the other act.
I've just gone blank. What's CMA?
Customs and Excise Management.
Thank you.
So that was a...
That's the bit about the border officials not doing any investigations.
Yeah, and so collapsing a bit into the Foreign Prison-Made Goods Act point, which was all about having to identify a particular piece of property that can come from a prison as opposed to the product of forced labour, which is plainly a far more expansive point. But my learned friend, Sir James, has his point so far as it goes, but that's not what our case was about. That's all about the rationality of their decision-making as to whether, in their view, it was worth opening an investigation. That's not what this challenge is about. That's a rationality challenge, and one we specifically disavowed we were making.
This is where I need help. I understand. So you say the error of law is, you say they made their decision by reference to a misapprehension, namely that they needed to know what probably that they could identify. That was the error of law.
Yeah.
And so their decision, their polycentric decision, resources, whatever else, the other matters that are mentioned in paragraph 21, none of that arises because they can't get rid of the underlying legal error.
Yeah, there was an illogicality in their stance that they began with, you can't show us any criminal property, so we won't begin. But moreover, it's actually really difficult for us to investigate any of this for all of the reasons that they describe in their polycentric decision-making. That second point, we don't attack, we can't, given the state of the law, ex parte Birmingham, Corner House, and so on and so forth.
Your points 1 and 2, as I think I'm now repeating myself, turn entirely on establishing, one, that you are correct as a matter of law that proof of criminal property, specific criminal property, is not required, or certainty or reasonable belief in, reasonable suspicion in proof of specific criminal property is not required before an investigation should be launched.
Correct.
And secondly, that that was an error of law adopted by the respondent for the purpose of making its evaluative assessment of whether or not to open an investigation.
Correct. And of course, Malone and friends for the respondents say, we didn't do that at all. You're
Right.
completely misreading our correspondence.
Right, so it is actually, in that sense, a narrow point.
Yeah, it
Well,
is.
Is the first point conceded? Is it conceded? We'll hear from Sir James, but is it conceded by
Yes, it is.
the government, by the NCA, that it is, you do not require proof of specific criminal property?
Yes, it is. So if you
Right.
if you look at their skeleton argument
Thank you,
references
thank you.
in the supplementary bundle at tab 4,
Yes,
so first point is page 39, paragraph 47.
thank you.
In my submission, when you read that, the plain meaning is that they accept evidence of criminality in a general sense and at a high level is not a threshold that prevents an investigation.
Sorry, which paragraph?
Paragraph 47 at page 39.
No, 47, page 39. Thank you. Sorry. Right, page 39, 47. I'm not getting that from paragraph 47. The evidential difficulties. Is that the paragraph?
Yes, if you read on, its relevance was that the material submitted by the appellant went to the existence of criminality in a general sense and at a high level. It was not necessarily evidence from which any irresistible evidence could be drawn, etc., etc. And then the last sentence, these were not suggested by the respondent or the judge to be thresholds to be satisfied before any investigation could be launched. So they're not there, they're suggesting that there is any threshold that incorporates that notion. And at paragraph 53 of their skeleton, they say, first, it's never been the respondent's position that it would be inappropriate to commence an investigation to proceeds of crime in the absence of a threshold requirement being satisfied.
Yeah, I've highlighted this, that's right.
Yeah.
So, accurate property, that's it, also does. So this is, so the respondent turns this into a rationality
Correct.
approach, and that's why, what I picked up from paragraph 2, you say that none of that arises, and you say you wouldn't make a rationality challenge because of all the authorities which point away. You say there was an error of law. If the law is this, you don't need a threshold. And 2, in a way, perhaps it's a terribly narrow point for us. It is, but the NCA did adopt that threshold for the purpose of making its decision. And all we've got to go on to resolve that is the correspondence.
Exactly, as the letter.
Is that right?
Yes. So my submission that the battle lines were drawn, so we turn back to the critically important letter, which is the decision letter.
Yep.
And I don't know whether my lady prefers it in the core bundle, it's at tab 22, or in the supplementary bundle.
It's
appears
everywhere, Mr.
It is, it's all there, you can't get away from it. At tab 17, to which you choose. But I'm picking up the one in tab 17 of the supplementary bundle at page 332.
That's the same as core bundle, page 746.
Correct, my lord.
Am I allowed to use page 7.
You can, my lord, yes. I'm sorry to try your patience. And can I just stand back from this letter and make this point? I'm not seeking to persuade you that you shouldn't read this letter as a whole.
Because paragraph 33 is going to be very,
Yes.
James.
Yes,
I suspect.
I agree. I'm not seeking a myopic or unrealistic interpretation of this document. My submission is actually, it's very straightforward about what was written in this document, and it's clear on its face what they meant and intended to say here. So at 332, or if my lord prefers at 746, they join in with the pre-action protocol letter in paragraph 1, that letter dated the 16th in that first paragraph. So we're joined in. Then there's an overview about meaningful action, in which they say, here's what the defendants are doing about this problem in China, and statements that the government have made, and so on and so forth. So soft power, if you like, being exercised. And then at 6, paragraph 6 over the page, they stress it's important to appreciate that the circumstances in Xinjiang and the issues you raise more generally remain under close review by the defendants. Then 7, they say, secondly, just picking up the third sentence, likewise, to the extent that the claim touches on the handling of criminal investigations or potential investigations, those are matters for the police and prosecuting authorities. It's entirely, judicial review is entirely inapt. I agree, if I was making a rationality challenge. No problem with that paragraph at all. Then they, at paragraph 7, take up what was called Decision 1, which was in respect of the Foreign Prison Made Goods Act part of the claim, which we're going to appeal against. But Roman numeral 2, in respect of Decision 2, at little b, they turn to the POCA aspect, because, of course, the pre-action protocol letter had asked them to begin an investigation or commence an investigation and explain, if not, why not. And my learned friend Mr. Fisher showed you that earlier this morning. An investigation premised on potential breaches of the Proceeds of Crime Act is misconceived. In the absence of specifically identified criminal property and criminal conduct, POCA is of no application. Well, in our submission, that's to be read in the present tense, as in then, now, not on the basis that, well, if we did investigate, we think that, generally speaking, it's very unlikely that we'd ever get to that standard of proof, so we're not going to try. And then Roman numeral 3, in respect of Decision 3, which is slightly different, but it's the last sentence of that paragraph, because it links back, where they say, no such criminal property has been identified. So again, putting the emphasis on identification by the claimant of actual property that was tainted, nor do any obligations arise, underline any obligations arise under POCA, to which any authority is required to have regard. Because, in essence, they're saying, you simply haven't given us a body to investigate. There's nothing to see here. And then they turn their attention to Decision 4, which doesn't concern us, and then they deal over the page with the background. That's all about the respective roles and responsibilities of the various respondents that were in play at that stage, and we don't need to trouble ourselves about that in my submission. Then paragraph 12, Foreign Prison Made Goods Act, they turn their attention to that. And they spend a lot of time on that, going through all of that over the next page, and about how the legislation was not designed to protect people in prisons. It was a piece of protectionist legislation, and so on and so forth. And then over the page we get to Customs and Excise Management Act, which links in to Section 1 of the Foreign Prison Made Goods Act. And then we deal with hypothetical case, which I'm sure my learned friend Sir James relies on. But at 23, having at 22 noted you don't particularise any specific consignment of goods as having been imported contrary to Section 1, of course that was a different issue, because that's all about an enforcement officer seizing goods on the quay at Tilbury, for example. 23, there's no principal basis on which to conclude in the absence of specific evidence that certain identifiable goods are prison-made goods. So that, again, that's all about foreign prison-made goods. 24, still on that same topic, but the last sentence on that page, on paragraph 24, the NCA's position remains that there is currently no sufficient basis on which to mount a criminal investigation. These are matters further discussed in the context of Decision 2. Notwithstanding the above, it's recognised that should the circumstances warrant it, for example, if the intelligence picture were to change, we don't rule out an investigation, and they refer to their letter that they'd made earlier in these proceedings on the 26th of May 2021, which is at page 288 of the bundle for my lady's reference. It would be a different reference for Dean, obviously. But I simply invite you to read that. So we get to Decision 2 in the middle of that page, and paragraph 29, they set out all of their polycentric considerations as to why they're not going to investigate. Fine, that's fair enough. Don't challenge any of that. And then at the bottom of the page, paragraph 31, they pick up POCA specifically. So far as concerns are alleged, failure to investigate possible money laundering offences under POCA, the letter before claim proceeds on a misapprehension. I rely heavily on that. There is no proper basis for a POCA investigation. And then 32, they simply set out what would be required to prove money laundering offences at the end of an investigation. So they accept in the first sentence that those specific crimes are in principle engaged. Then Roman numeral 1, they set out things that are not controversial about what it would be necessary to prove to instigate a prosecution. And then Roman numeral 2, they deal with this issue of adequate consideration. And just in the middle of that paragraph, although it's not my part of advocacy, just in the middle of that paragraph, in my submission, they get into a muddle there. Do you see the sentence starting, that provision reflects the policy aim of POCA, that it is not the function of the regime to taint, and then this, very important words, the bona fide purchaser for value. I agree. Rather, it's to seek the recovery of the proceeds of crime in the hands of a criminal. But of course, the defence under section 3292C is not the bona fide purchaser for value. It's simply somebody who knows or suspects, but has paid value. They're completely different things, and they have mistaken them for one and the same in that paragraph. And they're still, in my submission, doing that in their skeleton argument. There is a significant and important distinction between those two types of people, if you like, which makes civil recovery, in a case such as this, if it were investigated, a real runner, although I don't have to demonstrate that. And I'll just come back to why that's a real runner so far as civil recovery is concerned when I come to the end of these submissions about timing, because they relate to the provisions in Part 5 and about growing family tree of property and how it's not cleansed and unless and until you're the bona fide purchaser for value. So paragraph 33, this is when they deal with their assessment that my lady was asking from Mr. Fisher about. And they just set out what their assessment is. There was no evidence of this assessment in the proceedings. And at the end of Mr. Justice Dove's judgment, he simply quotes this paragraph as evidence of what they had been up to, without more. I think from paragraph 90 onwards of his judgment, he says, let's be fair to the respondents. They haven't been sitting on their hands. Look at what they say in this letter about assessment. And
But what about paragraph 34? Isn't that terribly important?
yes, I agree. And
So that it'll be said that shows that there was an evaluative assessment.
yes, in the present circumstances.
Present circumstances, no basis, but you say,
But that's a rationality challenge, my lady.
yeah, so you say they've still got it wrong at the first
Yeah.
stage.
Yeah. They've simply moved to stage 2. What they could have said in this letter is, our difficulty is that you haven't actually identified property, goods on the docks, for example, in Tilbury, that you say are tainted. That's a real difficulty for us. What you have shown us is fertile ground for potential criminality. Our decision is, given our resources, given our wide discretion in these matters, given other issues that we've got to deal with, and given the limitations which we say there are in the material that you've shown us, that there simply isn't sufficient material at the moment to develop a viable investigation. Viable in the sense that it's likely to result in a charging decision.
And you would have said no challenge to that. Couldn't
Absolutely,
challenge.
absolutely.
And so that's what they could have said. What do you say they did say?
What they've said in this letter, to start with, is that you haven't identified any criminal property. And then they go on to say, well, and moreover, we can't develop any lines of inquiry. But the starting point and the ending point of it is you haven't identified any criminal property, and that is a necessary requirement before we begin. That, in my submission, is the plain meaning of this document. And that is the reason that the critical plea was framed in the way it was in the grounds and the claim form. And when the respondents joined issue with it, they joined issue with it in the sense they tried to collapse it, as I've sought to demonstrate, into a rationality challenge, as opposed to grappling with the issue, which is, well, no, actually, we didn't do that at all. That's not what our letter meant. Our letter was, well, it's by the by, actually, you haven't actually shown us any identifiable property, but the reason for our decision are all of these polycentric reasons which are for us to decide. We could have had no complaint about that.
But if you're right that what they said was you haven't identified any criminal property, and without that there's nothing to do, why do they go on to develop the polycentric stuff?
Well, because it's more flesh on their bone. It's a sort of, point one is this, but moreover, don't come back to us because we've decided, even on the material that you've given us, that we can't possibly develop this. It's a belt and braces approach to the material that they were being given.
If that's right, then this would be a Pyrrhic victory for you.
Well, I can see that. But I agree that this is a rather sterile debate. I think Mr. Talbot described it in his skeleton argument on behalf of Spotlight as sterile, because the respondents concede that, of course, we don't need you to identify criminal property to begin an investigation. They accept that in their skeleton. But the problem is that the impression in my submission of the judgment is that you do require that. That is what people are reading in the real world, Mr. Justice Dove's judgment. And if the impression that they are getting and are receiving is that the authorities require people to identify, not to a specific standard of proof or anything like that, but just to say, look, there's property that's tainted, so it gives us something to look at, and they won't look at anything unless we're able to do that. And that's the problem with this judgment. In other words, if it goes uncorrected, it's going to have a very chilling effect upon investigators, we would submit, to use the tools that are available in the Proceeds of Crime Act to investigate the sorts of high-level and general evidence about criminality that those who instruct them presented to.
Well, I can certainly, speaking for myself, I can see the force of the submission that the judge didn't grapple with. I've said this before, sort of the critical bit is that last bit of paragraph 80, which just isn't really fleshed out.
Exactly.
What was the approach and was it right?
So, to be fair to Mr. Justice Dove, though, and it's by the by, but it was an extremely fair hearing in which the judge showed genuine curiosity about
sure.
all of these matters.
I'm sure.
There can
No
be
doubt about that at all.
about that at all.
No, I'm sure.
But if you pick up in the judgment, please, at paragraph 4, he does identify the critical plea.
Yes. I read
Because
that.
he says at the end of that paragraph, the central concern of the claimant under both of these grounds is the defendant's view that there is a need for specific criminal property to be identified prior.
And he never comes back to it.
Correct. And I could take you through this judgment, unless Mr. Fisher has done it, where essentially, just for your note, at pages 623 to 624, he quotes the decision letter, in particular paragraph 33. He sets out the law accurately at 625 to 626, and that is completely sterile ground because everybody agrees about it. At 629 and 637, he does the law in relation to POCA, again, completely sterile ground. And then at 638 to 639, paragraphs 50 to 52, he deals with what are described as the evidential difficulties that would be presented in investigating this sort of case. And I agree that they could well be difficult, but that wasn't the challenge that we were making. And then at...
So you would politely say, so what?
Correct. And then at 642, page 642, sorry, he picks it up at paragraph 67, and he states at the end of that paragraph, the defendant essentially relies upon the same submissions in relation to both grounds 3 and 4, and asserts that there is no proper basis in the claimant's material for an investigation under the 2002 Act. Well, that's a rationality point. And then he identifies at paragraph 70, again, the critical plea. You see in the middle of that paragraph, about 2/3 of the way down, furthermore, even where a specific consignment to be required in order to satisfy the definition of criminal property, that could not properly be a requirement before commencing an investigation in relation to money laundering. So again, he identifies the critical plea. At 72 onwards, he deals with powers under Part 5. At 75, he gets, in my submission, into the same muddle, I don't mean that disrespectfully, as was in the letter dealing with adequate consideration, because you can see, do you see where he picks it up, about 3 or 4 lines down? This approach is supported by the terms of section 3293A, which provide that consideration which is significantly less than the value of the property would amount to inadequate consideration. As a result of these provisions, if a purchaser has bought a consignment of cotton goods from China bona fide and at market value, any taint passes to the purchase price and the criminal property remains in China. Well, that's the bona fide purchaser. That's not adequate consideration within section 3293A. So there's the muddle right there in paragraph 75, but not my part of this case. And then he deals with his ultimate conclusions, and they really start at 78 in my submission, which is setting out what the defendant's case is, which is really the question-begging case. What would be the point of starting this if it's not likely to result in a viable prosecution? That's 78. And then 79, right at the bottom, and this is of fundamental importance in my submission, he says, the defendant's submissions which are recorded above are grounded in the position set out in the correspondence. So that is key. And then at 80, he simply says, having reflected on the respective position of the parties, I'm not satisfied that there is any legal error or misdirection in the approach. And then he sets out, essentially, thereafter, what's necessary to prove money laundering offences, and I don't quibble with any of that. And then right at the bottom...
Sorry, just to interrupt, my fault. I've been unfair, haven't I? Bottom of paragraph 80, where I said the judge didn't identify what he meant by the approach. Well, he did identify that in paragraph 79.
And 78.
And 78.
Well, he identifies the approach and all of those reasons that they advance while they're exercising their discretion.
Hold on. Would you just give me a moment?
Yes, of course.
Thank
Sorry.
you. So... Oh, well, yes. So he's paragraph, the approach, as you rightly emphasise, says the approach is whatever is set out in the correspondence.
Yeah.
So it's grounded in the correspondence, that's the approach. But he doesn't actually say whether the approach is, well, he doesn't say in terms that his construction of the correspondence is that the approach was to proceed on the you've got to have the specified property before you do anything
Brett,
approach. He doesn't say that in terms.
It doesn't deal with the critical plea at all. There is no determination of it. He simply, in my submission, determines the case against the appellant on the basis that this is a rationality challenge.
Then, but look at the, if you go back to 78,
Yeah.
so far as either, so penultimate line, so far as either a criminal or civil investigation is concerned, the defendant contends that there is little point in commencing investigations which do not have a realistic prospect of any successful conclusion.
Yeah. I agree with all of that. I don't quibble with that.
But, yeah. Thank you. Yes.
Had he have said, I disagree with the claimant, their construction of this letter isn't sustainable, and all that the respondents were doing were, when looking at it holistically, setting out that there wasn't much here to go on. They weren't laying down some hard and fast rule that unless you show us X, we can't possibly start. He could have said that, but he hasn't. And when the judgment refers to the critical plea in not one place, but two places, in my submission, this must be corrected because it's wrong, as the respondents concede rightly, that you don't need identifiable criminal property before you begin an investigation. And in those circumstances, if the judge simply failed to determine the way the claim was put, that must be an error. It didn't grapple with the critical plea at all. So maybe that's how I put it. Can I just turn up something which isn't my area, I know, but it's to do with family trees of property in civil recovery.
Yes, and I just need to be refreshed. You said that this arises out of the respondent's skeleton.
Well,
Something in the respondent's skeleton.
The point that's the sort of big ticket item, if you like, in this case is, does adequate consideration cleanse property? And they say it does, as I understand it, at any rate, for the purposes of the offences themselves under the Act and for civil recovery purposes.
So does adequate consideration from anybody along the chain cleanse the property once and for all?
It only cleanses the property in the hands of the bona fide purchaser for value. And that is a different idea from somebody who just provides adequate consideration. And of course, that is in section 308 of the Act, which my own friend Mr. Fisher took you to. So the Act is very specific about what cleanses recoverable property in 308. And the best way to illustrate growing family property is,
So forgive me, so you say no cleansing in part 7? No cleansing in part 7.
Pure defence. Pure defence, no cleansing unless they're bona fide purchaser. If they're a bona fide purchaser, they don't need the defence anyway.
Correct. Correct.
So it's somebody with a different state of mind from bona fide.
And rather irritatingly, it's not in the authorities bundle because it was already copied in the core bundle.
What's the it?
It's the judgment of Mr. Justice Laddie.
Laddie, yes.
103, page 103.
103, thank you. Grateful to Mr. Talbot. So if we just go to
Core
that.
bundle.
Yes. Is it 103 core? Page is it?
Yeah, right there.
Squirrel, isn't it? It's the case of Squirrel. Let me just check my notes. I'm sorry, my lady.
I don't think it's the core bundle.
No, it's the judgment. Core 332, the decision in Olaputan.
That's right. It's authorities bundle 103 for Squirrel.
Yeah, 332. So can I just turn my back on you a moment?
Squirrel is authorities bundle 103.
103, thank you. Yeah, sorry, I'll get this right in a moment. I'm mixing my... It's actually authorities bundle, the case of Squirrel, tab 6. Page 107 is the passage.
Paragraph 16.
Where he takes up the proposition that the whole purpose of the disclosure provisions in 328 is to provide information. It's not to punish innocent people. So POCA is thereby has a system by which the disclosure process is feeding information into the NCA all the time. And that's very important, therefore, when you consider how that might operate in a civil recovery case. And you can find how that's dealt with in Olaputan, this decision of Olaputan, which is in the core bundle at tab 11, please. My computer's just closed down, I'm afraid. Which isn't very helpful. Thank you. Where Mr. Justice Carnworth, as he then was, deals with various provisions in POCA, and then he deals with the explanatory notes, and it's page 201, please.
that's right. Is it 201?
Oh, is it 171? Is it the bottom, middle bottom? Page reference, 171, I do apologise.
Right, so 327 of the bundle.
327 for the pagination. Thank you to Ms Hardcastle. And he picks up the purpose of section 278, dealing with recoverable property, where it's traceable through different owners in different forms. States that the explanatory notes are helpful. So I just thought this was a simple way of showing you how a family tree of property develops. So there's potential for a large family of related property to grow up as a result of such a series of transactions, comprising the original property and several items of representative property. Each of these items will potentially be recoverable. But if the enforcement authority were to recover the entire family of recoverable property, that would be disproportionate to its right to recover the original property. So in effect, the point of section 278 in terms of civil recovery is a limiting provision, whereby if the court has a growing family tree of property, it can only recover that which is the total value, if you like, of recoverable property, not more. So it might take from one bit of property, might take from another. It can't take more than is the total value. And so just with that very small example in that judgment, thank you, it's just a simple shorthand for illustrating to you 2 points. One, 308, bona fide purchaser sets out that does clean the property in that person's hands, so that innocent party can't have that property taken away from them by the court. 2, there is scope for a growing family tree of property. How does the Act deal with that? Well, it has this limiter on it in 278, section 278, so that there isn't a disproportionate impact. And in my submission, that demonstrates through the Act, when looked at as a coherent whole, that mushrooming or family trees of property are specifically provided for by this legislation. And it's for investigators to follow that property wherever it may go. Well, lady, those are my submissions.
Thank you very much indeed. Any more questions? No, thank you very much indeed. Back to you, Mr. Fisher.
Thank you. Please, my lady. Mr. Forster has certainly helpfully done quite a bit of work for me in the sense of foreshadowing the adequate consideration submissions. There are 2 submissions, and they are independent. They are freestanding. They are not dependent on each other. The first is that we say that where adequate consideration has been given by the purchaser of a product, the giving of adequate consideration does not extinguish the taint of criminality or operate to cleanse the property by acting as a circuit breaker as it travels along the supply chain. So our position is this. Section 3292C establishes a limited personal exemption from liability. The exemption does not affect the status or potential status of property acquired, used, or possessed by that or any other person.
I'm surprised there isn't any authority on this. I mean, this must be a point that's come up before.
I know, and one speculates, but it may well be that at the end of the day, when one's looking at the application of adequate consideration, it obviously takes place within a commercial context. And most of the money laundering cases really tend to involve drug trafficking or that sort of case. And it just may be that this has not come before the court because at the end of the day, there actually haven't been that many prosecutions of using money laundering in cases where there has a commercial background, commercial transactions involved. And it is speculation, but it may be that that's why that you haven't had this issue before the court.
It's not an exemption that runs with the property.
No, it doesn't run with the property. Exactly. And our second submission is that on its proper construction, the exemption applies only in a situation where a person receives criminal property as adequate consideration for the supply of goods and services.
My fault entirely. Would you mind just repeating that?
Yes. The second submission, we say, is that on its proper construction, the exemption applies only in a situation where a person receives criminal property as adequate consideration for the supply of goods and services. As I say, it's a discrete submission. It's not dependent on the first one. They can be treated independently. But our second submission is this, that in other words, the exemption applies only where the adequate consideration is the provision of goods and services.
So how do you
Doesn't
get to
it?
that?
Yes, so
How do you get to that proposition?
I was going to tell you.
Do I sense a nervousness about your second proposition?
Sorry?
Do I sense a nervousness about your second proposition? Or less
No,
confidence?
I'd put it in this way. I mean, my lady just said it is right to immediately foreshadow the argument and say, well, how do you get there? Because, of course, if you look at the way in which the exemption is expressed, it's not limited in that sense. But if you then go on and look at a number of things, one is look at the way in which the statute does, the whole section works, but the way in which the exemption works more broadly within the Act. If you look at the construction that we say should be put on this sort of exemption, we believe there is a properly arguable case for you to consider.
All right, that's helpful. Thank you, Geraldine. So do you want to take the first?
Yes, so can I suggest we look at I think the letter's probably the best thing to do. Look at that. Yes, the protocol letter, the supplementary bundle, page 332, I think.
The 10th of September letter?
Yes.
Right.
I can find it because my file. I think I've got my file.
No, I haven't.
I'd much rather have mine. I've marked it out. Thank you. Lady, sorry, just a logistical matter. I just want to
Don't
get
worry at all.
the right document.
And if you just want to foreshadow where you're going,
Yes.
do feel free to break whenever you would like. We're running
Thank
up
you.
to 1 o'clock.
Yes, no, thank you very much. Let's just get the right document in front of us. I'm sorry. Where I want to go and to start to break this point down is to pick it up, page 338, in paragraph 32, small 2. Lady, if I may, we still have a few minutes left before
Yes, of
the
course.
shortage.
Whenever.
Our submission really is that the NCA and indeed the learned judge just simply fail to appreciate the legal position. In paragraph 32, small 2, in the second line of that, where we can see the author of this letter writes as follows: however, it is a defence under section 3292C. Well, actually, to begin with, it's not a defence. It's actually not expressed as a defence. A defence in law is different from an exemption.
It is, yes.
And so that's the first point to be taken. The point is that the exemption simply says that as a result of this, there is a personal exemption from liability. No, nothing more, nothing less. And so in that sense, it's quite wrong. My learned friend then quite rightly pointed out, Mr. Forster, that in fact the language, they've not understood the policy aim of the Proceeds of Crime Act. It's not the aim of the regime to taint the bona fide purchaser for value. Well, of course it's not. The aim of the regime is to do something different, which is to really ensure that proceeds of crime are removed from society. That's what it's about. And certainly the one thing that section 3292C is not about is the bona fide purchaser. The one thing that the adequate services beneficiary, as it were, is that one thing he's not is a bona fide purchaser. We wouldn't even be in the territory of criminal property if it wasn't for the fact that he knew or suspected that there was a criminal origin to the property. If he didn't have that knowledge or suspicion, it wouldn't arise, and then he would be a bona fide purchaser. So Mr. Foster is absolutely right when he deals with that point. And so the approach that the NCA took, and which the judge endorsed, is simply wrong. And it's wrong also later on in this paragraph.
Isn't the later bit the critical bit?
Well, it's all critical in the sense that it betrays a fundamental misunderstanding of the legislation. And so to that extent, we do pray in aid what's gone before. But indeed, the last bit of it cements it. If that product has been the subject of a transaction for adequate consideration, the relevant criminal property would be the proceeds of the transaction in the hands of the criminal or seller and not the product. Well, it depends. It all depends. Depends on the level of knowledge and level of mental awareness. And that's why I was keen to point out to you exactly how Section 340 works. Because it may well be that in the hands of another person who knows or suspects that the property has a criminal origin, it will indeed be criminal property, even though it's reached that point through somebody else giving adequate consideration for
Your
it.
point is that once you put that into context and you say, and you allow the concept that something can be criminal property in the hands of A because of A's knowledge or suspicion, but A may not be susceptible to prosecution because A has given value for it. It can then go into the hands of B, who has absolutely no knowledge, and it ceases to be criminal property for that basis. He then passes it to C, who is entirely a malefactor and knows perfectly well what it is, and C is still responsible, and the property can be seized from C.
Precisely. Yes.
And that's how it's supposed to operate.
Yes.
Because otherwise you'd find that somebody who has the requisite knowledge that would fix them with liability were it not for this exemption has somehow put a spanner in the works, to use the vernacular, of being able to recover the property which is still the proceeds of crime.
Well, exactly.
And that's bizarre.
Yes, and it would lead, and one of the submissions I was going to make is that it would lead to a marketplace in criminal property.
Yes.
That can't be right. Yes, the respondent and the learned judge have fallen into error. The respondents led the judge into error. And so that's how we do indeed put our case in relation to this. The idea that adequate consideration operates as a circuit breaker is simply wrong. And that's indeed how we put the matter. Forgive me, I'm just wondering, we've still got a couple of minutes. So can I then deal with another short matter, just by way of examples to how this...
We're still on the first submission.
Yes, we are.
Yes, that's
we
fine.
are.
That's good, just checking.
Just to think through some of the surprising consequences which would follow if the NCA were correct in their view. My lady has highlighted one. I was going to highlight one in a commercial context. That suppose a property investor purchases a residential property for £1 million. He knows or suspects the vendor is a drug trafficker, and he uses the proceeds of drug trafficking to buy the property in the first place, which, if I may say, as I understand it, and the respondents will know more, but is quite not an uncommon scenario. The property investor then does a quick turn and sells the property 24 hours later to somebody else, let's say a property developer, for a profit of 1.1 million. On the respondent's case, the property investor is exempt from criminal liability under Section 329 for acquiring criminal property. And we would say that simply can't be right. If the property developer knows or suspects the property represents the proceeds of drug trafficking, then they'll be in the same position as the property investor. And so in those circumstances, it would lead to that marketplace in criminal property, which cannot have been the intention of the Act, which is simply another way of expressing what my Lady Justice Andrews has just put to me, but in expressing a more commercial context.
Yeah.
My lady, is that a convenient
Very convenient
place to
moment.
stop?
Are you going to take us after the break to Affalabi and Hogan and say whether either or
Yes.
both of them was wrong?
I was going to do it right at the end, yes, I was going to make some submissions on those two cases.
Thank you. You're on track. You're doing very well time-wise.
Thank you. Good. Thank you.
Thank you for your submissions this morning. We will resume at 2 o'clock. Thank you.
Bye.